Good afternoon. This is Ann Bittinger, the owner of the Bittinger Law Firm. Thank you for joining us for our September webinar entitled, Uh-oh, Our Business Associate Won't Sign Our HIPAA Business Associate Agreement, What You Can Give On and What You Can Insist On in Business Associate Agreement Negotiations. This is the latest in our monthly Uh-oh sessions, in which we provide education on subjects that we get calls about on a frequent basis. We try to address issues that are relevant to what we are doing here at the practice. It seems like we would find that clients would give us a call and say, uh-oh, we're having XYZ problem. And so we came up with the name for the Uh-oh series because we would find that clients, often physicians or company CEOs or practice administrators, would call us and say, uh-oh, we're having a problem. Got a few minutes to discuss it, Ann? And then so as we saw trends, we developed the Uh-oh series webinars. I have muted all of your lines. If you have questions at the end of the presentation, you'll see my email address, and you are free to email me. With that, let's get started. Business associates are required under HIPAA. This session here today for the next 30 minutes is going to be somewhat advanced. So I'm going to assume that listeners have a basic understanding of the HIPAA privacy and security rules, especially as modified by HITECH and the Omnibus Rule. I'm going to talk about things hopefully pretty simply, though, and in an operational standpoint. Business associate agreements, as I said, are required under HIPAA. One assumption that I make from a client who calls me about a business associate agreement is that the client has a tailored HIPAA program. You'll see here on this slide I have a picture of a gentleman getting a suit jacket made or tailored, perhaps resized. I'd like to start off our call today with the notion that if you have not tailored your HIPAA program to your practice, if you have downloaded one from the internet or from an association website and not really gone through a security risk assessment or tailored the policies and procedures to what you're doing in your practice, then your execution of business associate agreements won't make much sense. Not only will they not make much sense, but you'll probably have some problems when the Office of Civil Rights Auditors send you a letter, which we all should be expecting this fall as the desk audits start, and they request a copy of your HIPAA compliance program. And then if they see this program that you send them, you know, your policies and procedures, and if the only change from the one that XYZ Physician Group Association of America had put on their website is the name of the practice, you're going to have some problems. You might have a visit from the Office of Civil Rights, and you might be fined because you are required to have proper policies and procedures. So that's one of the assumptions that I make. Secondly, as a part of the HIPAA program, I assume that my client has implemented an effective business associate identification process tailored to its business. So with that, let's talk about briefly who a business associate is. Again, this is a high-level talk today, and I'm not going to get too much into the detail of how to identify your business associates. I'm at the next step in the process here today, talking about how we negotiate the terms of them. But just as a side note, there are risks in wrongly identifying entities as business associates, as well as in not identifying them. My shortcut in terms of my analysis of identifying whether an entity is a business associate is identified here in the 3 bullets on your screen. Is it another party? Like, is this really part of your own workforce, or are you sharing information with another party? Is what you are sharing protected health information under HIPAA? Is it really PHI that you're sharing? Does the other party have access to it and need it? and are they doing work with that PHI? And then the third one, which is really sometimes the tricky one, is are they doing work with that PHI on behalf of you as the covered entity, as the hospital, the physician group? Are they doing something for your benefit? If those three things aren't in place, and again, this is a shortcut analysis, then that party is probably not a business associate. On the other hand, I often see clients that are sending business associate agreements and spending a lot of energy in sending those and trying to get them signed to entities that really aren't business associates. For example, other providers that you're sending information to who are covered entities, but you're not really having them do something on your behalf. They're doing their own thing for HIPAA purposes with it. So in a nutshell, I'm assuming that my client already has identified that this entity that we're talking about is indeed a business associate. And then thirdly, I'm assuming that as a part of the program, it has a very good business associate agreement, not one downloaded from the Office of Civil Rights website. Indeed, I'm assuming that their business associate agreement is tailored in my client's favor. Let's talk just a moment about the risks of using a template business associate agreement. There's a very sufficient one on the Office of Civil Rights, the OCR website. It contains everything that you need to have in there under the business associate agreement requirements under HIPAA. However, I want you to think about this for a moment. If you're a physician group and you are sharing your PHI with another company, whether that's Iron Mountain, loading your paper records and loading them off to a site to shred them, or it's Microsoft because you're storing your information on the cloud, do you really want to have just the minimum requirements in place to protect your client's protected health information? Do your patients know that you have only the minimum requirements in place that you need? And if the headline in the newspaper is that your practice had a breach of protected health information, how secure are you going to feel if all you had in place in terms of your contract with your business associate, who, by the way, is really responsible for the breach, was the minimum requirements that you need? I'm sure that doesn't make you feel very good. So what we're going to talk about here for the next 25 minutes or so are some of the other things that we put in business associate agreements. We're going to talk about some of the essential elements, but also some of the other things that are really the things that get pushed back in negotiating with business associates, and that are things that are really important to protect you from a holistic healthcare law standpoint. Let's talk about the business associate. So we have another party who we need to have sign the business associate. It amazes me in 2016 that there are businesses out there in the healthcare informatics or in the healthcare industry that, as a daily part of their services, touches PHI, and they don't know that they need a business associate agreement. It just amazes me. Whether it's a bank or a storage unit, or others seem to be a little bit more up to speed, but it's often that my clients say, "Can you call their lawyer? They don't think they need to sign a business associate agreement." And I say, "Okay, this is going to be fun." But basically, the 8 items that I have here on the screen are requirements that actors within the healthcare industry that touch PHI, in other words, business associates, have had to follow since either 2010 or 2013, whether it was in high tech or the omnibus rule, whichever. They have to have policies and procedures to protect PHI. They have to have technical safeguards. They have to perform a security risk assessment, just like you do. They have to have policies and procedures and documentation standards for protecting PHI in their company, just like you do. They have to have a HIPAA security officer. They have to have BAA signed now. They have to agree and in their operations limit the use and disclosure of PHI as it is specified in the agreement. So they can only use the PHI for what the contract says they can use it for. And they have to facilitate access for amendment, accounting of disclosures, and to get copies of records, which we'll talk about in a few moments. They have to agree to open their books and records to the Department of Health and Human Services for an audit. And by the way, the Office of Civil Rights of the Department of Health and Human Services has said that they're going to focus on auditing business associates in the next year. So we'll see how that goes. And then, of course, they have to agree to return or destroy PHI if feasible upon contract termination. So some of what I do as a healthcare lawyer, either in representing business associates, I do a ton of that work, but also in representing covered entities, is explain to business associates that they basically have to do essentially the same HIPAA privacy and security work that a hospital does, that Florida Blue does. So you can imagine an IT company that routinely has access and monitors your EMR. Have they done all of these things? Does it scare you that they might not have, even regardless of their federal legal obligations? It's interesting how there is such a disconnect out there. So let's move now to the title of our talk. What happens if you send your business associate agreement over to them, to the other party, and I'm assuming that now in 2016 this is probably a new company that you're doing work with because you already have your business associate agreements in place with all of your existing business associates. And we have this battle of the forms. So you send your 5-page contract over to them, and then they respond by saying, no, we're not going to sign your form. And what we have is this kind of, well, we see their form, we see our form, and clients will call me and say, Ann, I didn't really understand what our business associate agreement said, or really have an understanding in terms of what we can negotiate or give on. So what I advise clients on at this point in time is, what can we give on? What's the next step? Okay, so to understand what we can negotiate and give on, or what we might want to counter offer with, we really need to identify what really matters. Now again, I'm assuming that the business associate is not objecting to the things that are in that template Office of Civil Rights business associate agreement that is in the HIPAA regulation that they have to do, okay? Because, there's really no negotiation there. They have to sign that stuff. But there's a lot of nuance in how they do those things. And there are, like I said in the beginning of my talk, some things that are things that you probably want in order to protect this important thing that you're storing, your patient's health information, that is not in HIPAA, but that matters in the implementation of the security components. So let's dig in. What really matters? One of the things that I see lacking most in other parties' business associate agreements is some reference to the underlying agreement. So the underlying agreement is kind of a legal term. It's not like lying down underneath something. It's the contract for the services. So if you're a practice and you were having your old paper records shredded, and a company with a big truck was going to pull up in your parking lot and start loading those boxes in the back of their shredder, or taking the boxes away to their site to be shredded, you're going to have a contract with that company. And it's probably just going to, in passing, talk about HIPAA. It's going to talk about when they're going to come. It's going to talk about what they're going to do, just your general run-of-the-mill contract. Well, as you could see from my previous slide, a few, ago, you really have to, as I say in number 6, limit the disclosure in your business associate agreement of PHI as specified in the agreement. So you can't do anything with the PHI except what the underlying agreement says could be done. And this is a huge problem. Not only does it not comply with HIPAA if you don't reference it, but it creates a huge risk. So let me have you step back with me here for a moment. What we're really doing in a business associate agreement is making sure that this other party that we're giving our PHI to protects it. If they don't protect it, you want to be able to show that it's their fault, not yours. Sorry, this is the lawyer in me doing my job. We really want to ensure that the PHI is protected, that it isn't breached, that it isn't flying out in the wind, that it's not all over the internet, and so on and so forth. But what we're really concerned about also is that the liability is clear. So if we don't have clear roles and duties defined, or at least referenced in another agreement in terms of what they can do and what they're prohibited from doing with the PHI, it's hard for me to say who's responsible if there is a breach. And if you've seen the fines from the Office of Civil Rights, you know we're talking about a huge amount of money. So I really like to get really basic about it. I did one business associate agreement recently with a big document retention company, and I wanted to know when in the duties, is it their duty to load the boxes of paper records into the box? Like, who's responsible for that? Like, if a box gets left on the sidewalk, whose responsibility is that? Whose HIPAA breach is that? Is that the document companies, or is that my clients? And even getting down into that nitty-gritty can really help prevent some liability. Let's move on to the representations and warranties in the business associate agreement. You know those funky whereas clauses that are usually taking up most of the first page of a contract? Whereas this party does this and whereas this party does that. Sometimes those contain representations and warranties. So whether they're in the whereas clauses or in another section way buried at the end of the agreement that's titled representations and warranties, I like to have my business associate that I'm doing work with represent and warrant that they have an effective HIPAA plan, that they have things in place. And I might get really specific about it because some of those things are required by HIPAA, like I had shown on my other screen previously. But there might be some specific things, like, I don't know, I might want to specify that they have coding training, or they train their coders on HIPAA issues on a regular basis because those coders are going to have access directly into my EMR, so on and so forth. So there might be some specifics that we want the BA to represent about and warrant to the covered entity that they have in place, because it kind of goes to the I told you show, and I'll get into that a little bit. This is really intended to be kind of an overview slide. We're going to talk about the delineation of roles and whether the BA is an agent acting on behalf of the covered entity. Another thing that matters and that we see going back and forth a lot on is the turnaround time for access, amendment, and accounting of disclosures. Another thing on my list that may perhaps be the most important thing that matters is if there's a breach and the business associate knows about it, it's a breach on their end, when do they report it to the covered entity, to patients, and to the media? Another issue that really matters that might not be in the forefront of your mind are what I call the 3 I's: insurance, indemnification, and injunctive relief. I'll get into that more in just a second. And then another issue is, if something's not going right, how the heck do we get out of this agreement? So termination. So reference to the underlying agreement. I kind of jumped into this a lot in my overview slide. But if there is a breach and we want to determine who is responsible for the breach, of course it helps to know who is responsible for what. So this helps with breach notification and with indemnification issues, which I'll talk about in a little bit. Remember that HIPAA requires that business associate agreements describe what the permitted uses and disclosures are. So you might need to have your business associate agreement specifically reference, for example, the services agreement entered into between the parties on September 9th, 2016. Like, I would get that specific with it. It also helps to reference the underlying agreement in terms of breaches other than security. If you feel like there's a problem with the relationship, or that they're not protecting PHI in perhaps the ways that you would like them to, or perhaps they're not getting you patients' records or information in the time that they should be, you want to be able to terminate the relationship. And you can't really terminate the relationship if the duties are not clear. So you can't show that they're in breach if you can't show what they are in breach of. So finally, another reason to reference the underlying agreement is simply how to do it, is to reference and incorporate it. And so what that means is kind of a legal term, like I had said earlier, that we're incorporating the underlying services agreement that the parties signed on September 9th, 2016. Okay, so moving on to representations and warranties. This is kind of the, well, you told me so approach. So let's say that the business associate says that it has XYZ in place. Let's say it has in place a legally compliant HIPAA program, perhaps with some other details and other things that are specific to the relationship. Some examples of what they can represent are that all staff has been trained on HIPAA, perhaps within X days of being hired, that they have an effective compliance program, that they have meaningful protections in place for your patient's protected health information. Let's say that they represent and warrant that they have 3 layers of protection at all times. For example, if it's a storage company, instead of just saying something general like they take reasonable protections, maybe you want them to represent that they have layers of protection in trifold. So meaning there might be a lock here, there might be a passcode here, and then there might be another lock here before you get to the box of records. And then similarly with an with a contract with a company that's servicing your EHR or that provides it, maybe you want them to represent and warrant that their firewalls are checked at certain intervals. So you can see there's a broad range of what they can represent and warrant. And what I'm getting at here is, frankly, have them put their sales pitch into their reps and warranties. You know that these companies are coming and puffing their chests and saying, we are the most HIPAA compliant, we are HIPAA certified, which, by the way, there is no HIPAA certified anywhere in the world. No one can be certified as HIPAA compliant. It's a falsity. Don't believe anybody that says it. Say, oh, really, how? How are you HIPAA certified? Who certified you? And what do you have in place? And then the things that they tell you that they do, get those in the agreement. If, have them put their sales pitch into a representations and warranties section. Next, another issue that comes up a lot is the delineation of roles and agency. Now, this is something that a non-lawyer's eyes might just skim over as just being a standard HIPAA language, but it's a really big deal in terms of being able to identify who's responsible and therefore liable for a breach. Agency is a legal theory. An entity is an agent of another entity if that entity has the ability to direct and control that entity's conduct. For example, if you hire an independent contractor to come to your house, let's say it's a plumber, and he's coming in to install the dishwasher, that person is really not your agent because he's not acting on your behalf. You have no ability to control or direct his installation methodology, right? An agent is someone who you control and direct. So in all of my agreements that I write for covered entities, I specifically say that the business associate is not your agent. And I'll put something in there that says that covered entity has no ability to direct or control the business associate's conduct as to the PHI. Because if they're on their own and they're doing it, then they're the ones who are responsible for it. That little paragraph that business associates slip in their agreement when they give you their form back could have a provision that says that as the business associate, we're acting as the agent for the covered entity. And in doing that, you're taking responsibility for their actions. This was actually a new component of the omnibus rule back in 2013, and its legal significance should not be underestimated. Then there's the issue of the days. That's the best way to describe it. It's the days conundrum. And what happens here is we'll have the covered entity will say, you have 3 days to get back to us in this event. And then they'll give you their form back and they'll say, no, we have 60 days to get back with you on that. And then the covered entity might counter and say, well, how about 10 days? And then they'll come back and say, well, how about 30 days? So why does this matter? The text here on the side sort of explains the 4 different areas where this comes up, and I have those highlighted in red font. So to amend, to account for, and to access records. These are 3 components of the privacy section of HIPAA. And what we're talking about here are individual patient rights. So a patient has a right to amendment of their PHI within certain degrees. A patient has a right to an accounting of disclosures, which is they can get a list of who all has received their information. Patients also have a right to access or get copies of their records. And what I've put in here for you are the time frames in which you, as the covered entity, has to get back to your patient on this. So, for example, let's go down to the 3rd one. Let's say that a patient asks for a copy of their medical records, okay? And you know that some of their records are at XYZ storage. So you might have in your business associate agreement that the business associate will respond to you with requests from patients for access. So if the patient asks you and then you have to ask the storage company, you have 30 days to get back to the patient, and then you have another 30 days, so a total of 60, but you got to touch base before the 30-day mark to say, hey, we need another 30 days because of XYZ situation. So you can imagine if there's said 60 days, like it says here in the visual on the top right, that if you don't get it back from them for 60 days, then you'd have a darn hard time getting it back to the patient in your 60-day deadline. So sometimes, you know, a day or 2 doesn't matter. I just did one for one side, and it had, you'll get back to us in 2 days, and they came back with, okay, how about 3 days? And I was like, well, that doesn't really matter. That's fine, whatever. What's the difference in 24 hours as to access, accounting, and amendment? It's not that big of a deal. But you can see the time frames are a little bit different for accounting and for an amendment. The plus means that you have to have an initial contact within the period, and you can request or you can get an additional 30 days. So you can see if you're somewhere in the 15-day period, you're going to be fine on all of these, even 30, even some, but we see these days coming back and forth. I did not forget the item at the very bottom left. 60 days is the time that the covered entity has to report a breach to the media and to the secretary if the breach involves more than 500 patient records. I get a lot of pushback on this one because I think that business associates want to control this process a little bit more than the covered entity might think that it should. So there's actually a provision in HIPAA that says that the business associate has to notify the covered entity of a breach without unreasonable delay and no later than 60 days from their discovery of the breach. So as a lawyer representing covered entities, I love that in the regulation it says that the business associate can't unreasonably delay. So I like to make sure that this language is in there, this without unreasonable delay, because that could be just a couple of days based on the facts and circumstances. And what you're talking about here is that you know your business associate has let your patient's protected health information be violated, be disclosed, whatever. You don't want to wait 60 days to know that, because the fact of the matter is you're going to hear it from somebody else before that. You want them to act without unreasonable delay. So as to a breach, make sure that that language is in your business associate agreements. As you can see, the negotiations can go back and forth. Next, I want to turn to insurance, indemnification, and injunction. These are not things that are required at all by HIPAA. You know, I sometimes get a red-lined business associate agreement back, and the other side has put, this is not required by HIPAA, in the little comment box in the margin. And I'm like, yeah, it's not required, but if you want our business, this is what you're going to have to agree to. And we'll talk more about that leverage in just a minute. Insurance, I always put in my first go-around that the business associate is required to have HIPAA insurance, or insurance that protects against breaches, perhaps maybe HIPAA and beyond. Believe it or not, there is this insurance out there, and my understanding is that it's not cost prohibitive, especially if you compare it to malpractice insurance and some of the breaches that are going on out there. Pushing it a little more, you can ask as the covered entity to be a named insured. That just means that the insurance that they're buying names you as an insured entity on their policy. That's pushing it a little bit, but it doesn't hurt to ask. Let's move on now to injunction. It is so much easier to walk into the courthouse and get an injunction if you have language in your contract where the party that you're pursuing the injunction against has already agreed to it. So I just add something in there that says that in the event of a suspected breach, that the business associate consents to an injunction. Finally, my favorite one, indemnification. Now, here's the concept here. You know, I'm a Midwesterner. I'm pretty common sense as I go on these sorts of things in life and in business associate agreements. The concept is that if you mess up and I'm sued for it, you're going to repay me for that. It's a pretty simple concept. That's what indemnification is all about. The business associate messes up, the covered entity is sued, and there's a judgment against the covered entity, then the business associate has already agreed to reimburse the covered entity for that. I always ask for it, and it's probably one of the things that if there's a lawyer reviewing for the other side that we get pushback on. So I have a system for what happens if they balk. The first thing I might say, and think of the tennis ball going back and forth over the net in the negotiation here. Number two, if they balk, then I'll say that, okay, well, we'll indemnify you if you indemnify me. What's good for the goose is good for the gander. Let's both agree to indemnification. You know, if we mess up and you're sued, we'll reimburse you. Well, if they balk at that, then I sometimes put a limit on the exposure, whether it's in dollar amounts or just limit it to the payments that, you know, we paid you for your services, or maybe some sort of type. So there's lots of ways to limit the exposure. So I sometimes say, well, what are you scared of? I mean, what do you think could go wrong that you're not willing to take responsibility for? Help me here, and maybe we can come up with some solution. So if they balk at that, remember the purpose here. Just because there's not an indemnification provision doesn't mean you can't still sue them if you have to pay out a fine or if there's a judgment or whatnot. So there are other ways for you to tee up a good lawsuit against them if you suffer because of their malfeasance. And these are things mostly that I talked about earlier. A good duties description. We want to make clear that this was their responsibility, not ours. put in that the loser pays attorney's fees so that you know you're going to sue them, and at least they're going to have to reimburse you for their attorney's fees. Mandatory arbitration usually makes it a little bit easier and quicker than going to court. It is also, in this age of breaches in headlines and newspapers, a little bit more private. I would say that venue is where my client does business. I'd ask for insurance because the fact of the matter is, if they have insurance, they're more likely to indemnify, or at least come through. It's all about the money. It's not necessarily about the principle sometimes. Well, if they have insurance that'll pay for it, then maybe they don't care. And then another issue is who pays for the notifications. If there is a breach, the covered entity, perhaps the business associate, but usually the covered entity, has to send notices out to patients, has to put it on their website that there was a breach, contact the media, and so forth, depending on the size of the breach. That's costly. So maybe if we at least can keep our costs down by saying that they're going to reimburse us for that process, that might be helpful. So that's kind of the negotiation I go through. In terms of termination, do you have the right to terminate and get your PHI back, or to require it to be destroyed? Is that in your contract? Which do you want? If there is a problem, if there's a breach of the BAA versus a breach of the underlying agreement, can you get out of that underlying agreement? So this is the, how do I not do business with these people anymore? If there is a breach, can you imagine that if they breached the security rule and breached your business associate agreement, but your breach terms, or excuse me, your termination terms in your BAA do not allow you to terminate the underlying agreement, and you still got to pay these people for what they did, and what they would continue to do even if you say we're not going to do business with them anymore? So my point is, link up the termination provisions in the business associate agreement with the actual underlying services agreement. Overall strategy. So who has strength here? Some covered entities are in the position to say, hey, we will go to your competitor because they'll agree to do this. If you're not going to agree to our business associate terms, I'm sorry, but we're not going to do business with you. That's how important our patient's PHI is. So have a strong template as a starting point. That's a great way to do it. It's just like if you're buying a car. Of course, they're going to start with a price that's really high, right? So having a nice, strong, very pro-covered entity template as a starting point is a good one, because you're going to negotiate perhaps somewhere in the middle. That being said, don't be ridiculous. But I think some of the terms that I discussed here, most good healthcare lawyers would not say that these are ridiculous terms. Be sure to dedicate time and resources that are necessary for negotiation. I've seen a lot of non-compliance in terms of executed or non-executed business associate agreements because an administrator or a manager or a director sent the business associate to the other side, sent the business associate agreement to the other side. About 2 weeks went by, they sent their template back, and it's just kind of sat. So be sure that you have the time and resources necessary for negotiation and getting back on this. Believe it or not, a good healthcare lawyer can turn these things around pretty quickly because we do them all the time. Thirdly, assess who has the power. Do they want your business or do you need them? And ask for a healthcare attorney to help you when you need it. In closing, this is really important stuff. As a way of doing business in 2016 in the healthcare industry, covered entities rely extensively on third parties to do things for them with their protected health information of their patients. It's very important. The risks are great that there could be a breach, and simply that you could violate HIPAA by not having the information that you need in order to respect the patient's rights under HIPAA. The fact that the OCR has said that they are going to do desk audits, meaning they're going to send letters asking for your policies and procedures. They're going to ask you, have you identified your business associates? And perhaps even ask for copies of those executed business associate agreements. means that now is the time to go back and make sure that you have your business associate agreements in place and that they are good agreements going forward. With that, we'll sign off, and we look forward to seeing you next month. Thank you very much.